All right, welcome to another episode of the Accidental Landlord. I'm your host, Peter McKenzie, and today we are going to be talking about landlords being targeted for lawsuits. And these come from a couple different places, but today we're going to talk mainly about the ADA Act and the Fair Housing Act. So ADA stands for Americans with Disabilities Act. It's a federal law. Then the Fair Housing Act also is a federal law. We'll get into what the differences are, but there's people out there who file lawsuits against targets. In this case, it would be a landlord or a business owner or a building owner. And for, a lot of these lawsuits are what we call predatory lawsuits, meaning they're just out there trying to make money, and they're less about the intent of the law, and they're more about how can we scam the system to make a lot of money off what I consider a lot of times are innocent people who are just trying to run a business. So we're going to talk about some examples. We're going to talk about some specific cases. Some of this is maddening when you think about it, but I think it's really important that we bring awareness to this. That way we know how to protect ourselves, and we can hopefully not be the target of some of these unscrupulous actors that are out there. We're going to give you some strategies on how to deal with your obligations to these laws, because for sure these laws are serious. They have teeth behind them, and you have an obligation to follow them. So we'll talk about what that looks like and what the risks of not following them are, what some of the penalties can be. So let's just jump right into it. So for starters, the Americans with Disabilities Act, it's a relatively new law. It's basically designed to protect people with disabilities, and it mainly focuses on public areas. So this covers the grocery store, common areas. Obviously, we're a podcast about real estate investing and landlords. This does apply to some multifamily buildings where there are public areas. Think a leasing office, a playground, the pool, those types of things. But generally speaking, the Americans with Disability Act doesn't apply to the interiors of the units, or like a single family house or one condo or inside an apartment. That is covered by the Fair Housing Act. Similar protections for people with disabilities. The laws are not the same. And I do want to just say a disclosure. I'm not an attorney. I'm not giving legal advice by any means. We're bringing awareness and some education to what these laws are and how they apply to our businesses. So Fair Housing Act covers disability. It also covers more than the Americans with Disability Act. So race, creed, sexual preference, those types of things. And there's a long list of those, which most people are familiar with. These laws overlap each other. So in some cases, there might be let's take a multifamily building, which a lot of our listeners own or clients have. You might be covered on ADA in the common areas and FHA on the interior of the units. It's usually whichever law is stricter is the one that you have to follow. So it's your obligation to keep up on these laws, understand them, how they work, and what your obligations are. What we feel is our obligation is to bring awareness to sometimes how these laws are abused and what you can do to hopefully make it so you're less of a target when it comes to that. Now, we're in the state of California. The state of California has layered on more laws, specifically the Unruh Civil Rights Act, the Fair Employment and Housing Act, and the California Building Code. There's no way we're going to go into what all of these mean specifically, but just know that these laws expand on the federal laws for all intents and purposes, make them more difficult, more strict on top of what the federal government already has done. So let's talk about the key areas that we need to be concerned about as landlords under the ADA law. And there's three areas. One is parking accommodations. So the ADA sets standards for accessible parking spaces, how big they are, what the signage needs to be. If you have a multifamily building where you have parking spaces for disabled people, you need to take this seriously, because if you don't, there absolutely are people out there who will target you and file a lawsuit against you because of it. The other area that to focus on are accessible entrances and routes. So think ramps, wheelchair access to fronts of businesses. Think, how wide they are, lighting, signage, all of that stuff. So if you're in a wheelchair and someone comes to your building or your place of business and there's zero way for them to get where they need to go, that's clearly a problem. The other area that we're going to talk about briefly is communication accommodations. So ensuring that the tenants have the ability to communicate with people who have whether it's a hearing impairment, a vision impairment, speech impairment, those types of things. So you have obligations there. Think those TTY systems, large print documents, accessible leasing processes. So if you have somebody that is blind, for example, and they have no way to figure out how to rent an apartment from you, that would be a case that would fall under this area. The other one is service and support animals. Now, there's obviously a difference between those two things. We're not going to get into specifically what the difference is, but service animals typically are for a disability, like the person has trouble seeing, hearing, they have a seizure disorder, and an animal alerts them to those things. And then support animals or emotional support animals, it's a little less clear cut. The burden of proof is a little lower. They still need a healthcare provider to certify or prescribe the use of them. But there's definitely some misconceptions between the two. The support animals usually falls under the fair housing rules, not necessarily the ADA rules, and the service animal more falls under the ADA rules. But if you have a situation where you're presented with someone with either of those, you need to make sure that you're up on the proper best way to handle that. And then the last area is in maintaining accessibility features. So think that things that you put in place, like ramps and signs and things like that, you have to stay on top of this. So just because you put a wheelchair ramp in one time doesn't mean that your obligation is over. What if the ramp is constructed out of wood and it's deteriorated and it's no longer accessible? So maintaining these things is also something that needs to be taken into consideration. So that's the ADA. Now, the Fair Housing Act is more targeted to preventing people from being discriminated against based on belonging to a protected class. And I think everybody knows what a protected class is. It could be, someone of a particular religion, a particular sex, a particular gender orientation, language, creed. There's a lot of them, and there's even more in California than there are on the federal list. And if you have somebody, even some healthcare conditions are considered protected classes. If you have somebody there and they're requesting an accommodation from you, you have to take it seriously. You have to pay attention to it. Now, we could spend literally an hour on both of those laws, and there's other laws too. What I want to do now is talk about some case studies so that you get a real understanding for what the risk is here, like what is possible if somebody is going to target you for one of these things. It's not just a nuisance, it's something that you don't have to pay attention to. There's some real consequences here. So the first one we're going to talk about is something these are serial filers, meaning these people are filing as many lawsuits as they can to collect money, to collect legal fees and settlements. So the first one, there's a person named Jarek Molsky. He became a paraplegic in 1985 from a motorcycle accident, and he was known for filing over 400 lawsuits against small businesses in California, alleging violations of the ADA. They cited minor infractions such as inadequate handicap parking or misplaced handrails. Some of the codes have very specific, the handrail has to be at this height. You have to be able to access it by this many inches, those types of things. So he had literally filed over 400 of these things, meaning he's probably being driven around looking at people to target. That's how some of these players operate. So in 2004, a federal judge accused him of extortionate practices, labeling him a hit-and-run plaintiff. So they barred him from filing further lawsuits without judicial approval, trying to basically stop this guy. He appealed it up to the Supreme Court, which basically they declined to hear his case. So they essentially stopped him. Now, that doesn't mean that he doesn't go into a different forum like the state of California and start filing lawsuits there. So what this case did was it sparked significant debate between enforcing the law and preventing abuse of these legal provisions against business owners that were being the target of this. But it just also shared light that these laws are good, but they do have loopholes that allow people to exploit business owners and target them for these things, which highlighted the need for some reform. Now, there have been some attempts at reforming some laws to prevent this, but they're like criminals. If you make one law against something, they'll figure out a way around it and some other loophole to exploit. And I don't want to say he's a criminal. That's not what I'm saying. But just because they stopped him in a particular way didn't mean that they figured out a way around it to go do it in another way. So that was kind of the first one we're going to go over. This guy was filing 400 lawsuits, and the people obviously were trying to stop him. The next one is a gentleman named Orlando Garcia. He also was a prolific ADA plaintiff in California. He filed nearly 1,000 lawsuits going back to 2014. He was targeting small businesses, including landlords and property management companies, alleging minor accessibility violations. So he filed most of his lawsuits in federal court, although after he got too much scrutiny from the federal system, he switched over to the state system, the state of California. So again, this is a gentleman who was just exploiting people. 1,000 lawsuits. Imagine how many people's lives were impacted over that. Now, I also want to say, if we have someone who's disabled and they truly need access to somewhere and it's impacting their life, that we absolutely should provide accommodations to them. And if you have a business owner who blatantly says, no, I'm not going to, I don't care, and that disabled person files a lawsuit, I would say that's warranted. That's good. That's probably what the legal system's for. In my opinion, what it's not for is for someone to drive around town and file 1,000 lawsuits against 1,000 different businesses just because they can and they figured out how to work the system. So what was the impact of this Mr. Garcia? Again, similar. His actions prompted discussions, and lawmakers started talking about how are we going to prevent this abuse, which is good in general for sure. Okay, we're going to look at another one. And this is a Stephen Caston's properties. This is in 2022. And this is in our area, he owned 3 properties on Thousand Oaks Boulevard, which is just the town 20 minutes north of us. And he was sued for noncompliance with the ADA law. Yeah, they were saying that his buildings were constructed decades before the ADA law passed, and he's been targeted regarding accessibility issues. So this brings up a good point. If your building was, built in 1940 and the ADA laws weren't even a thing, what does going backwards and trying to make your building become more accessible mean? And then at what level and how far do you have to do it? And that was kind of what they were suing about here. Mr. Caston described the experience as legal extortion of property owners in older developments. So, but the ADA, I think, was passed in 1990. A lot of properties built before that were scrutinized by these unscrupulous lawyers for these minor infractions, which really created a lot of financial burdens with legal fees and modifications and all the things that you have to do. The moral of the story here is take the law seriously. And if you know of anything that's wrong with your building, you should probably address it ahead of time. Okay, our next one is a gentleman, Joeseph Bodenstein, and AMI Real Estate. So in 2017, a tenant filed a complaint against this gentleman who owned the property and the property management company, alleging that they have threatened to evict them due to an emotional support animal. Now, this is a touchy situation, and we see this a lot in our business where people have emotional support animals. And there's a lot of people out there who think it's easy to scam the system. It's an easy way around a no pet policy, and that might be accurate, and some people may do that, but it is not our job to assume. We have to follow the law, and the law says that a healthcare provider has to provide a prescription for this animal to offset some sort of disability that they have. We don't have the right to know what the disability is. We don't have the right to know how it offsets. We just have the right to know that a healthcare provider authorized this, and then we have to comply with it. This gentleman, they allege, threatened to evict this person because of this quote-unquote emotional support animal. This is a problem, and I see this a lot in our business, and I've seen landlords who tried to do this, and my recommendation is that you do not do this because the consequences are not good for you. So the people who brought the lawsuit was the California Department of Fair Employment and Housing, and they did find that they violated the Fair Employment and Housing Act and the Unruh Civil Rights Act, which is the California-specific law. And the way it all ended was the case was settled with the landlords agreeing to pay $28,000 and to implement anti-discrimination policies, including revising no-pet policies and providing fair housing training. So there you go. It was a simple, I don't know all the details, but I've seen it time and time again. Tenant gets a pet, doesn't tell the landlord. Landlord goes, there's no pets here. Tenant goes, oh, it's actually not a pet, it's an emotional support animal. The landlord more than likely didn't believe them, so said no. they get the the California Department of Fair Employment and Housing involved, and all of a sudden the landlord has to pay a fine and jump through a bunch of hoops. It's not worth it. It's if they provide the documentation, accept the animal, and move on. Where it gets tricky is sometimes the insurance policies on these properties prevent certain breeds. They call them dangerous breeds, which is a whole nother controversy. But so a landlord ends up in a position where they are either going to get their insurance canceled or they have to break the fair housing laws. And I wish there was clarity on that. And frankly, from what I can tell, there isn't much, which is why sometimes it's so tough to be a landlord in California. So something to keep in mind. Okay, let's move on. So the next example is with the same agency, the Department of Fair Employment and Housing, and they sued the Corporation for Better Housing and Domus Management Company. So this was in 2018. A tenant had mobility impairments. They filed a complaint against the owners and the managers of this apartment community in Oakley, California. The tenant was unable to leave her third-floor apartment due to an inoperable elevator and requested a transfer to the first floor unit. Despite the availability of the unit on the first floor, the request was delayed for over a year. So obviously that seems like a pretty serious issue if you have somebody who's in a wheelchair and they're on the third floor and the elevator's broken and they want to move to the first floor. That seems relatively reasonable request. So what happened was the department determined that they violated the Fair Employment and Housing Act by failing to provide a reasonable accommodation. This case was settled with the landlords agreeing to pay the complainant and implement measures such as fair housing training and posting informational materials. They didn't say how much they had to pay, but I can guarantee it wasn't a couple $100s. This goes back to the same thing. If somebody requests an accommodation from you, you as a landlord, whether you are a professional landlord, whether you're a mom and pop landlord, whether you only have one rental property, including whether you're renting a room in your house, you need a process in place for what to do when that happens, because it will happen. This is a relatively common thing. And ideally, you have a process in place that is approved or vetted by your attorney so that you're keeping yourself compliant. So those are just some examples of case laws. There's obviously a lot more. Some of these, sometimes it's hard to find what the actual settlements were because some of these, are covered by privacy agreements where they're not going to disclose the results and those types of things. But these are a couple examples of landlords who got into a pinch, who didn't do everything they were supposed to do and got burned for it. Now, the serial lawsuit filers, probably not the landlord's fault necessarily, and that seemed more of like a system problem, like the system was allowing one individual to file 1,000 lawsuits, which in researching for this podcast, there have been some attempts at some reform of this law. Again, though, it's like once you put something in place, they just figure out another way to go around it. And if you've been in business long enough, this is true, and it can be frustrating, but progress is progress, which is a good thing. Let's talk about protecting your property and how to prevent some of these things from happening to you. So you don't have to do this alone. If you ever try to go research laws and look at all the ones that apply and make sure they're not conflicting with each other, it's a nightmare. There are professionals out there that can help you with this. There are attorneys who specialize in the Americans with Disabilities Act, both on the plaintiff side and the defendant side. So there are attorneys who specialize in these things. There are also service providers like property management companies, which is something that we're the business we're in, who can help you with this as well. So you want to make sure you're doing a proactive ADA inspection. And don't just do it one time. Do it maybe once a year or once every couple years, regularly, to ensure that you're complying with the law. And guess what? Laws change. The state of California cranks out laws so fast, your head would spin trying to keep up with them. So just because you did something 5 years ago doesn't mean you're all clear now. So it's something you have to stay on top of. It's about mitigating risk. And these are areas that property management companies who specialize in multifamily buildings, and they've been through these lawsuits and these complaints before, and they have some bruises to prove it. These are good people to partner with who can go through and make sure they're catching some of the obvious things so that you're protected, in addition to the attorneys and legal advice. They help you navigate the legal requirements, reduce the risk of lawsuits, all of the above. So what are the best practices for landlords? It would be the regular ADA compliance checks, inspections, especially if you have an older property. If your property was built before 1990, this is something that you should pay more attention to, because just because it's before 1990 doesn't mean you're exempt from this law. The next thing you should do is, if you find something that is a potential violation of the law, fix it. Just bite the bullet and do what's required to fix it. Because if somebody sues you for it, it's going to be more expensive. So get ahead of it. When you discover it, just take care of it, or put a plan in place to take care of it. Some of these fixes aren't cheap, but do something. Be able to prove that you're trying to address it in some way, shape, or form. Okay, so the other piece that I want to talk about is compliance with disability accommodations that aren't related to accessibility issues. And that would be, well, I'm sorry, I take that back, that are more connected to the Fair Housing Act. For example, somebody has difficulties with mobility and they're asking to put a handrail in the shower, or, potentially widen a doorway or something along those lines. Take that seriously as well, because you might not get dinged on the ADA side. You're for sure going to get dinged on the fair housing side. And we've had podcasts on this topic before with fair housing. It's not necessarily a trial. They have these departments that can come in and just arbitrarily do an investigation and figure out if you're guilty or not, which is not good for you. Now, there are lawsuits that come out of this, obviously, but there are these bureaucracies under these departments in the government that this is their job, which is to go enforce these laws and fine people that are breaking them. So take them seriously. There are people out there who are fishing for these things. So they recently enacted, I'll give you an example. They recently enacted a law in California about Section 8 vouchers, that you have to take them. You can no longer say we don't take Section 8. So recently, after the law was passed, there were people who were testing, and what the structure is behind these people, I don't know if they were working for law firms or if they were working for the Fair Housing Department. It's unclear because they don't tell you, but they literally will start asking you questions related to this. And if you give them the right answers, which hopefully you do, and you follow the law, then they just kind of go away. But if you don't give them the right answers, then that gives them an in to file a complaint against you. And there are people who go out there and test for these kinds of things. So if you're communicating with the public on anything related to these things, you've got to stay up to speed on the laws. Okay, let's wrap this up. So key points. Risk of ADA non-compliance and the potential for predatory lawsuits is real. It will affect your pocketbook. It will affect your reputation, which is almost more important. You got to take them serious. There are significant legal repercussions for not doing them, even on minor violations, which we've already identified from these serial filers who are just driving around looking for lawsuits. It's important that you get good advice. You surround yourself with professionals, whether it's attorneys who understand these landlord-tenant laws or a property management company who stays on top of these laws. They can help you mitigate the risks. This is extremely difficult to do in a bubble all by yourself. I don't recommend it. I think most people would say get professional help, people who know how the system works, because frankly, the system is stacked against you, not for you. Okay, if you need any more information, there's a ton of stuff online about ADA compliance and guidelines. You can reach out to a property management company like ours. Most people are interested in helping you, keeping you compliant and out of trouble. There's also legal services. There's legal law firms who put out, examples of all the new laws and what you need to know, kind of bullet points. Just find yourself a source of information that you trust so that you can not find yourself in the same shoes as some of these other landlords and business owners. As always, we appreciate your time for listening to these sometimes dry topics, but extremely relevant and important if you're going to choose to run a landlord business, which is essentially what you're doing, even if you have one little rental property. Thank you for your time. If you enjoyed this, make sure you subscribe. Feel free to reach out if you'd like to discuss further. Thank you.